pace of change continues to go at a tremendous speed. What I wanted to cover in the session this afternoon is the information we've got to date on the job support scheme, the new scheme which is meant to replace to a certain extent the furlough scheme. The information that we now have on the job retention bonus, further guidance was published by the government last Friday on that. Take a look at the change in the government stance on home working, which has caused quite a few problems for some employers, and a look at the new health protection, coronavirus restrictions, self-isolation, England regulations, like not a very snappy title there. Just as an indicative of how quickly things move, those regulations were published and came into force within 24 hours. So just a look at that and what it may mean for your business, and then we'll have time for questions at the end. So in relation to the job support scheme, now it is a little bit late in the government actually providing full guidance on this, given that the furlough scheme is coming to an end at the end of this month. We only have the initial information which they published shortly after the scheme was announced by the Chancellor. But, you know, there's enough to perhaps start considering whether or not this might be something which could be useful for your business. The aim of this scheme is to protect viable jobs throughout this coming period of the winter, when it's anticipated, because of the extra restrictions we're likely to be facing, demand for certain goods and services may not be as high as it would normally be. But the key to it is that it is about protecting viable jobs, and therefore the starting point to see whether or not an employee would be eligible under the scheme is whether or not they are working at least a third of their normal working hours. So for those businesses where they can't operate, the scheme will be of no assistance at all, because it's absolutely essential that the individual is working at least a third of their normal working hours. And normal working hours is going to be looked at we're told, in the same way in the furlough scheme. So if people were working variable hours previously, it's going to either be an average over the previous 12 months, or it will be looking at the corresponding calendar period. That's what we've been told, but we haven't seen the detail of the scheme yet. Now, the essence of the scheme is that the employer will pay for the hours which the employee actually works. So let's say, for example, an employee is working 50% of their normal working hours. The employer will pay for that 50%. And then if we look at the 50% of hours which have been lost, as a piece of pie cut into three pieces, the employer is going to be paying a third of those lost wages. The government will pay a third of the lost wages, but this is subject to a monthly cap of £697.92, and the remaining third is just simply lost. So that's how that's the essence of the scheme. It is worth noting that this grant will not cover employers' national insurance contributions or pension contributions. And therefore, it still represents quite a hefty investment for businesses in keeping these jobs, retaining these jobs throughout the winter. The scheme is eligible to all employers who have a UK bank account and run a UK PAYE system. It's open to all sorts of sizes of businesses, but small and medium-sized businesses will not have to pass any sort of criteria test in order to access the scheme. With large companies, and we don't know what a large company is going to consist of yet, but if it's looking at the Companies Act definition, it usually is businesses which have got more than 250 employees a balance sheet of over 16 million and turnover of over 36 million or something in those regions. But as I said, we haven't got the guidance that that will be the definition of it. But for those larger companies, they will have to show that their turnover has suffered as a result of COVID in order to be able to access the scheme. But small and medium-sized businesses do not have to worry about that, and they'll be entitled to access it anyway. And also, it's not necessary that you have used the furlough scheme. Obviously, when flexible furlough came in, it was a condition that to put an employee on flexible furlough, they needed to have been on the initial furlough scheme in advance. But furlough is irrelevant to this. It won't. The fact you haven't furloughed anyone won't affect your ability to make a claim against this scheme. There is a restriction on the employees that you can claim for, in the sense that there must have been on an RTI submission on or before the 23rd of September, which I believe was probably the day before the Chancellor announced the scheme. So that's a typical anti-fraud measure that they built in there. So you must have included them in an RTI submission before the 23rd of September. And importantly, the employee must not be on notice of redundancy. Now, on notice of redundancy, is quite a wide term. If it is sort of interpreted in the way in which the government had recently been interpreting on notice of redundancy, that is more likely to be they're not serving notice of redundancy. And so effectively, you haven't issued someone with a redundancy notice and said you're being made redundant on such and such a date, and so they're effectively working their notice. On a wider sense, redundancy could mean that, for example, you notify a group of employees that you may need to make some redundancies and you're going through a consultation process. So our best guess at the minute is that it's only those employees who are serving notice, as opposed to employees who have been put on more general notice that there may be redundancies. But again, we need to see the detail of the scheme. Some other points to note is that we've got very little information about how the third of the normal working hours is going to be calculated, whether for example, there can be any averaging up over a period of time, or whether it's got to be strictly every week they're working a third of their normal working hours. So that obviously we're expecting that very shortly, because the scheme will be up and running on the 1st of November. And as soon as that guidance is published, it usually is quite late on a Friday evening they publish these things, but as soon as it's published, then we will be sending a legal update out to clients, together with the draft letters that you can use. At the moment, we don't think it's, of course, you can start talking to employees who you think you might use under the scheme about the prospects of it. But I think in terms of actually getting an agreement tied up, it's probably wise to see the detail of the guidance before actually committing anything in writing to your employees. But we do know that the working pattern of short-term working must last for a minimum period of 7 days. As I say, the scheme is set to run for 6 months, but the government have already flagged that they're going to review the minimum threshold of working hours after 3 months. So it may be when they think that they've got the worst of the winter season over, that they may look to increase that. You can access this scheme and the job retention bonus scheme at the same time, so that's certainly something which is to be welcomed. But I have asked the question about whether or not this scheme is really going to be a way in which to save jobs. And in fact, I think next week we're doing another webinar about looking at the options for businesses at the end of the furlough scheme. Because actually, in terms of this being a solution, it really doesn't seem to be an ideal situation for businesses who are trying to cope with mounting debt and to be investing quite a lot of money in just actually retaining jobs. I can definitely see that there will be some benefits, for example, for businesses where maybe the skill set of their employees is really, really difficult to come by, and they want to retain those skills within the business. And certainly in those jobs where actually demand is really fluctuating, so you don't want to be making any permanent changes because you may need people to actually satisfy a sudden increase in demand at very short notice. However, there are other options which businesses could take, which would not mean, for example, if, most Citation clients have this in their contract, a right to put people on layoff or short-time working. That's a contractual right to put people on short-time working without actually paying anything towards the hours that they've lost. But as I said, these are options which I'll be looking at in a future webinar. So I'm not sure it's necessarily going to be the answer for a lot of employers. I suppose there'll be a question of a lot of financial considerations of what would be the cost of redundancy and what will be the cost of this scheme, and factoring in, of course, the benefit of the job retention bonus as well. So leading us on to the job retention bonus, we had further guidance published on this last Friday. So as you probably know, this is a one-off £1,000 taxable payment for each eligible employee that you have furloughed and kept continuously employed until the end of January next year. In order to be eligible to claim for this employee, and of course this is the employer's money, this isn't passed on to the employee at all, the employee must have been the subject of a valid furlough claim. They must have been continuously employed from the end of the last furlough claim that you submitted to them, for them, up to the 31st of January next year. So they need to be continuously employed throughout that period. They need to be receiving the minimum threshold earnings during that period, which I'll come on to talk about a little bit more in a second. And they must not be serving statutory or contractual notice. Now, in that case, statutory or contractual notice has been firmly identified by the government as you've actually issued them with notice of redundancy. Whether that's their statutory notice or whether you've got a lengthier period of contractual notice, they must not be serving notice of redundancy, because obviously that's an indication that the job hasn't actually been saved by the scheme. The minimum threshold is a total of £1,560 gross. We will be circulating these slides afterwards, so if anyone's trying to scrabble and take this information down, not to worry, that, as I said, the slides will be circulated. But that is the total amount that has got to be paid over three tax months. And they've been identified as between the 6th of November, the 5th December, 6th December, 5th January, and 6th January, 5th February. So it doesn't matter, and the 1,560 is a cumulative total for those months. And it doesn't matter, it doesn't have to be spread across evenly, but the employee must receive at least one payment of taxable earnings within each of those 3 months. So as long as they receive at least one payment of taxable earnings, and the total comes to at least £1,560, you'll have met the criteria for the threshold payments. And it is important to note as well that statutory sick pay is included for this purpose. So, leaving that to one side, I thought it might be just helpful just to touch upon the recent change in the government's position with regard to home working. As you will probably all recall, around about the 20th of July, Boris Johnson announced that there was going to be a much more opening up of people returning back to work when he announced the government strategy was going to be. It really was for employers to decide where jobs could be carried out. From the 1st of August, if an employer decided that a job was better carried out in work, presuming, of course, that the workplace was COVID secure, then people should go back to work. And of course, a lot of employers then invested quite a lot of time and money in making sure that their workplace was COVID secure, trained everyone on it, and were sort of caught a little bit on the hop by the fact that all of a sudden the exponential growth in the virus within the community again led the government to change their position. And the government's current position is on the screen now. This is what the official statement is, that to help contain the virus, office workers who can work effectively from home should do so over the winter. Now, I think there's been a lot of attention over that word effectively, because that's quite a subjective term. What might be effective to an employer might not be what the employee sees as effective. So there's been a lot of debate about how is this giving extra discretion to employers. Where an employer, in consultation with their employee, judges an employee can carry out their normal duties from home, they should do so. So that's really sort of embedding the principle, which I think the government has mentioned throughout when it comes to these decisions, is that these decisions should be reached in consultation with employees, but not necessarily with their agreement. Anyone else who cannot work from home should go to their place of work, and flagging, of course, that extra consideration should be given to those people at higher risk. Now, as I say, there's been a lot of employers who, over the weeks preceding to this change in stance, have been enjoying the benefits of having people back in the workplace. And who actually were thinking, well, I do think the job can be done more effectively in work. I want to keep people in work. I don't want them to go back working from home again. And I think there is probably three areas where I see employers get themselves in some difficulty when considering this. First of all, they don't really have any tangible evidence or any objective case for saying the job can't be done from home. They just think, well, I think it can be done better in the workplace, but they don't really have the tangible evidence to support that. And what I would say is that really needs to be your starting point if an employee wants to work from home and is saying, well, this is now government guidance. If you are saying they need to work, stay in the workplace or come back to the workplace, you really do need to really think of an objective reason why that's going to be the case. And it can't just be, well, I think it works better, or I think it's more efficient, because the chances are that is not really likely to stand up to scrutiny at a tribunal. The second area I feel that employers can get themselves tangled up is in relation to focusing on the individual as opposed to the role, and thinking, well, yeah, there might be some people who could do that job from home, but I have an issue with this particular employee. It's hard enough to get a full day's work out of them when they're in the office. I just don't trust them to work from home. Now, if you have a history of performance management and issues with that particular employee, where you could show objectively that they had a need for greater supervision by being in the workplace, greater support, that might be something to start looking at. But if it's just a question of you judging from everything you know about that employee, thinking that they couldn't do a role, but there's nothing to evidence that, and on the face of it, the role could be done from home, there's quite a few significant dangers of taking that approach. And the third issue, and one that I can absolutely sympathise with from an operational and a management issue, is really allowing your judgment on this to be swayed by the views of the wider colleagues. So the sorts of things that I come across a lot are, if I agree it for this person, everyone will want it. Or if I agree it for this person, I'm never going to hear the end of it, because everyone's going to be, complaining about the fact that they've been allowed to work from home. In fact, funnily enough, just before I came on the webinar this morning, one of my close friends who I met at law college, and so she's a solicitor, but she now runs a GP practice, actually ran into exactly this sort of issue herself personally, because she has got an issue where someone's threatening to take the practice to tribunal for disability discrimination and constructive dismissal, and because she hadn't been allowed to work from home. And she was saying things to me like, you know, it's just, if we give in to this sort of blackmail, it's just going to make us look weak to the other employees, which is, as I say, it's a classic trap to fall into. And anyone can do it. You really need to think about, if it goes to tribunal, it will be viewed on the basis of what is the right thing to do for that particular employee, and what can be objectively justified in relation to the way you've dealt with that particular employee's request. So try to always think that. And that's why it's so important really to take advice on these situations, because the consequences of getting it wrong can be very significant. We're already seeing tribunal claims coming in on this issue, and the President of the Employment Tribunals has given a direction that employment tribunals should prioritise these sorts of COVID-related whistleblowing and health and safety claims. So it's really important to take advice if you find yourself in this situation. And the key to it will be to consult with employees, as the government advises, because, I mean, first of all, you really need to understand why they're so intent on coming back, of staying at home, and they're so worried about coming back, how they feel that the job can be done at home, and how you feel, and explain to them where the difficulties are, just to see if there can be some common ground found. Finally, the new regulations which were introduced with the health protection regulations. These are the regulations which actually make it a legal requirement to self-isolate. So the actual duties to self-isolate are set out in Regulation 2. If you've either tested positive or as a result of a COVID test conducted after the 20th of September, or after the 20th of September, you've come into close contact with someone who was tested positive and you've been told to self-isolate. And that advice can be given by anyone in the NHS, including, of course, NHS Test and Trace, or it can be given by a public health official. So there is the duty to self-isolate, and if you don't do that, that's a breach, and kind of fines of up to potentially £10,000 for failing to do that if you're a repeat offender. The regulations put on a specific obligation on workers, and by workers I mean agency workers, casual workers if they were due into work, employees, to notify you as an employer if they are required to self-isolate, and they need to do that as soon as possible. And certainly before the next time they were due to attend work. This duty to report, the fixed penalty for not doing that is £50, which doesn't seem a lot, but of course, if they are reporting for work, they're already in breach of their duty to self-isolate, which attracts the much higher fine. But the obligation on you as an employer is that it's a criminal offence now if you were aware that a worker needs to self-isolate and you require them to go to any place to carry out work other than the place they were self-isolating. So obviously most employees will be self-isolating at home, so working at home is fine, but it would be a criminal offence to send them anywhere else. And this criminal liability attaches not just to the company, but also to individual officers within the business if this is breached as a result of their actions, their negligence. And the fixed penalties, you can see there, it's £1,000 for a first offence, £2,000 for a second offence, then jumping to £4,000 for a third offence, and then up to £10,000 for a fourth offence. I think the advice I would give about this particular piece of legislation is if hopefully you do have a policy to notify your employees what they should be doing. And if you haven't got one, I would absolutely do it, because I think it's really important that you've got your internal procedures in place so that, first of all, employees know exactly what they need to do. And we think we take it as read that employees will be following all the updates on the news, but I think sometimes at this point, it's almost a bit of snow blindness, really. People find it difficult to take information in. So make sure that your employees are aware of this obligation and who they need to report to and how they should report it, just to make sure that you don't find yourself in breach of these regulations. So in terms of just a reminder, obviously we've got the advice line support, 24/7 to help you navigate your way through these issues. But obviously if you find yourself in a situation where you think you need more help, perhaps you're dealing with a messy disciplinary or a grievance involving these issues, we are giving support to an enormous number of clients at the minute and trying to do this more directly through our on-site support service. And you've got details on the screen, and I'm sure Dan will be popping something in the chat dialogue box to let you know how you can contact us if you feel you might need support with there. So I think we're on to questions now.
We are indeed. Thank you very much, Jill, for that. There's lots of questions popping through, which is great to see. If anyone has any questions, feel free to use the Q&A function at the bottom of your screen just to ask as many questions as you would like, and we'll get through as many as we can in the next quarter of an hour or so. So, Jill, the first question I have is, if my business is COVID secure, can employees still request to work from home?
Well, yes, I think this is one question that we've seen quite often, because I think it's been very confusing for employers that the whole focus, when the emphasis was in getting people back to work, is that your workplace should be COVID secure. And then you think, well, actually, why do people need to work from home? Because it's COVID secure in the workplace. But it's taken as read that your business will be COVID secure. That's different to the question of whether or not people should be working from home. And as I said, government guidance now is that regardless of the fact that your workplace is COVID secure, if the job can be done effectively from home and the employee wants to do it from home, because remember, a lot of employees will not necessarily enjoy working from home and certainly may not enjoy working from home full time, but if an employee wants to work from home and it can be done effectively from home, that really the onus is that they should be home working, regardless of the COVID security of the workplace, which, as I say, is taken as it should be COVID secure in any event.
Perfect, great stuff. There's been a number of questions coming through in regards to the health protection regulations that we've just covered, asking about where does that actually cover. So there's a couple of questions asking, is it just in England? Some people have requested, is anything similar for Wales or Northern Ireland?
Yes, when it was announced, it was expressed that it was specifically England, and there is England in the actual title of the regulations. But and they came into force on the 28th of September, I believe. But at the time, the Prime Minister announced that actually this was being done in conjunction with the devolved administration, so that they would be bringing in separate legislation, so that I think the stance would be the same on this. I don't know whether that legislation has actually been introduced. It wasn't the last time I looked, but I haven't looked over the last few days. But I think that would be the intention, because unlike, obviously, it's been so confusing with different areas of the UK having different rules on things generally, but the essential elements of self-isolation, really I would expect to see consistently. But as I say, I haven't checked recently to see whether that legislation has been enacted.
Perfect, great stuff. Thank you, Jill. The next question is from Pasha, who says, if we have tried working from home with one member of staff in a particular role, and it hasn't worked, can we say that won't work for all staff in the same role?
Great question. I would say it depends on why it didn't work. In fact, we have got a tribunal claim on exactly this issue, where it was it involved, say, a department of about 6 people, and what the client was relying upon was literally a 2-day trial involving just a couple of people in the team. And the reason I think they're coming a little bit unstuck on it is the fact that the reason it didn't work was quite personal to the set of arrangements of those individuals. So where that would be the starting point, is why didn't it work? For example, within that particular case, someone didn't have access to certain systems remotely, which they should have had done. But if it's if it's something like that really would be a problem that you could genuinely anticipate everyone would have, because it's a system point, or it's a fundamental role of the operations, then yes, I don't think you need to trial it with everyone when you can quite rightly predict that everyone is going to have the same issue. But where it's more personal to the arrangements of that particular individual, for example, maybe they did have poor broadband, which meant that they couldn't access the systems or whatever. When it's the more individual, the less likely or the less beneficial that is to rely upon to say no to everyone.
Perfect. Great stuff. Thank you, Jill. Another question is, what if I can give some employees 1/3 of the normal working hours, but not others on certain weeks? Okay.
So this is something we don't really know exactly how it's going to work. The guidance, very scant guidance, which has been published so far, has said that you can, it refers to this term of cycling on and off the scheme. So that would mean if you have got an employee who you can give 1/3 of the hours, 1/3 of their working hours to, but not for others, you would have one employee getting the benefit of the scheme. Those other employees would not be on the scheme, and I'll come on to how you would treat those in a second. And then if, for example, you suddenly didn't have 1/3 of the hours to give to that particular employee, but you could give it to other employees, they would be on the scheme and that person would be off the scheme. So you've got the potential for people to move on and off the scheme, as long as we do know the minimum period of short-time working has got to be 7 days. That's why I think this is why we haven't just produced a letter for clients yet, because the key is when you're actually agreeing these arrangements with your employee is what happens for the time when you are not able to give them 1/3 of the hours. And what I would be suggesting is that, especially if you've got a short-time working clause in your contract, but even if you haven't, you can negotiate this now, that where they're able to give them sufficient hours to qualify under the scheme, you'll use the scheme. Where you don't, they will just be paid for the hours that they do. So I think everything that we've seen so far does seem to suggest they do accept people to be going off and on the scheme. It's really important that when you're agreeing it with the employee, that you do agree that at times when they're not able to make use of the scheme, they'll just simply be paid for the hours that they work. Which is why I think some employers are thinking, well, this just seems like quite a big headache for me to administer, just so that I'm giving my employees money for time that they're not working, whereas I could implement short-time working, wouldn't have to worry about any of those calculations. It's just I pay them for the work that they do, and we save the job. The difficulty with short-time working is that after a certain period of time, it can trigger redundancy entitlement, and that's as opposed to potentially, well, we don't know how the redundancy entitlement is going to be triggered under this scheme. I would think that employees, if they're getting paid 2/3 of the time they're not working, are much less likely to want to trigger the redundancy entitlement.
Great stuff. Thank you, Jill. There's lots of questions coming through, which is great. The next question is regarding the job support scheme. Do annual leave hours count towards working hours?
Oh, a very, very good question. Of course, they do for flexible furlough. We don't know. So this was for the this isn't for the job retention bonus. This is for the support scheme. Yes.
Mm-hmm. Yes.
Well, the answer to that is we don't know, but I will flag it when we do get an answer for that. I'll absolutely flag it. It seems to be that every time they put one of these schemes together, holiday seems to be the last thing they think about. Operationally, it's one of the things which is most important to you as an employer. There will be, obviously, for flexible furlough, they came out and said, look, holiday is included as working hours. It's tempting to think that actually they would apply the same logic to the job support scheme, because actually you would have had potentially would have had work there, but they may say that actually that's just you're just using annual leave to mask the fact that that job isn't viable because you haven't got the work to give them. So it could go either way, but we don't know the answer. But a great question, and definitely one to look out for.
Definitely. The question here, which is an interesting one, is from Alan, who asks, what should we do where we have an employee whose child has been told to self-isolate from school due to contact with a fellow pupil that's had a positive COVID test? We've already refused the request from that particular individual to work from home due to previous performance issues.
Right. Yes, these are great questions. Yes, so the employee doesn't have to self-isolate. So we know that that's a fact. Just because someone has been told to self-isolate because of contact with someone who has been tested positive doesn't mean to say that other members of their household have to self-isolate. So they don't have to self-isolate. But a lot of employers are taking the view that they want to be really rigid on this, and ask people to work from home just as an extra precaution. In this particular case, you have said that you are not particularly keen on them working from home, and I suspect the last thing you want to do is give the employee a taste of working from home for the next couple of weeks just to be on the safe side. But as I said, there's no legal reason why they can't come into work. But you may want to just be particularly mindful of, their setup and work, and do they need to be more distanced from their colleagues for a period of time, and be obviously extremely vigilant about, cleaning and things like that, which I'm sure you are in the workplace anyway. But, it wasn't really clear from the question of whether the employee is saying, I've got to work from home because of this. If that's what they're saying, that is not the case, as long as the workplace is COVID secure.
Perfect, great stuff. Next question is from Paul, and Paul asks, if an employee is working from home, are they entitled to claim expenses from the employer for electricity, broadband costs, etc.?
No, they're not. There is some sort of tax, I think, whether it's some sort of tax credit you can get or something. It's an accountancy point that I've not gone into, but they're not entitled for you to pay any of their electricity or heating, although we're anticipating seeing that inquiry coming up a lot now the central heating is coming on. But no, they're not entitled to that.
Perfect, great stuff. Amy's asked a question. She said, could you explain what you mean by short time working can trigger redundancy entitlement?
Yes, so if you are working. Now, I think there are very complex rules on this. I think from memory, there's a cutoff point. It may be 50% of working less than 50% of their normal working week for a 4-week period, or 6 weeks out of 13 or something like that. It's really quite complex statutory rules about this. Even though they're not laid off, it can actually trigger them saying to you, make me redundant. And if that happens, then you as an employer have got a specified period of time in which you can serve a counter notice which says, no, I want you to come back to work and at your normal hours. So it's a way in which that you can't put someone on short-time working, significantly short-time working, which, if I remember from the legislation, I think it's less than 50% of their hours for a very, very long period of time. If you're giving them more than that percentage of hours, it's absolutely fine. And who asked the question, Dan?
It was... I can't remember. I'm sorry.
Oh, okay. Don't. I know it's hard to read those screens.
It was Paul.
Oh, Paul. Yes. So I can send some more information, but it's just that whereas if you've been laid off for a period of time, you've got rights. Employees have got rights to claim redundancy, and then you can't really avoid that unless you are able to return them to work. It's the equivalent of that from short-time working, but as I say, I think the percentage is something like 50. It's got to be less than 50% of their working week.
Great stuff. Perfect. Next question is from John. And John asks, if an employee works less than a third of their hours, can we still pay them to top them up to a third? And then from that, can they still claim from the scheme?
I would, again, we haven't seen the guidance, but I would say no, because it's that would be seen to be an abuse of the scheme, I think, even though it's for the best of intentions because you're trying to retain the employee. But I think the focus of this is very much about the government only wants to give this financial support to viable jobs, and they've said viable is you must be working. It's worth noting that actually they have tightened up the anti-fraud measures in this proposed scheme from what we saw with furlough. And I think that's one of the reasons why there's a delay in this, in actually having the guidance published, because they're trying to look at that even further. You had the head of HMRC coming out recently talking about potentially £3 billion worth of fraud being committed under the furlough scheme. So there's a lot of effort being given into making sure that this is absolutely every I is dotted and T is crossed with this. And two measures that they've taken in particular is, unlike furlough, where the onus was on getting claim money or grant money out as quickly as possible, and with the job support scheme, this money will only be paid to you after you have paid the employee. So that wasn't a condition of furlough. Again, this makes it even less attractive for employers because they've got to find the money in order to be able to recover it from the government. But HMRC will check your RTI to check that money has actually been paid before they pay you. And also, unlike furlough, they are going to be informing your employees directly of how much that you've been paid in relation to them, so that because they want to avoid a situation where, because it's very difficult for them to know how much time employees have actually been working. So this is a way by HMRC contacting the employees directly and letting them know. It'll make the employees aware just in case things are not as issued. And then, of course, you're going to have your whistleblowers hotline to HMRC in relation to that. So my view would be that even though that would have been done for the best of intentions, it's probably still going to fall under abuse of the scheme.
Great stuff. Thank you, Jill. We had a question earlier from Alan who asked about self-isolation for parents if a child has to isolate. A couple of questions off the back of that particular one. The first one is from Jane. I think she just wants to, if you can just clarify. She said, did you say if an employee's child has been told to self-isolate, the parent doesn't have to? First of all, is that correct?
It depends on why they've got to self-isolate. Because if it's just in the child, they'd be in a bubble with someone who's got a positive COVID test, they need to, and they've been told to self-isolate because of that, that is not going to trigger the rest of the household self-isolating. Obviously, if it's a positive test and they're self-isolated because of that, that's something different.